Professor Hale snatches the legal brief from Zara's hands, holds it up in front of the entire lecture hall, looks her up and down once. Mismatched sneakers, worn hoodie, notebook clutched to her chest. Then drops it on the floor deliberately, the pages scattering across the marble. He doesn't raise his voice. That's what makes it worse. Let me be very clear about something. He addresses the hall, not her. This is Yale Law School, not a shelter, not a charity program. He finally looks at her. I don't know what gave you the idea that a black girl off the street could walk into my lecture and pretend to belong here. But I can assure you, sweetheart, whatever you think you read in whatever library you slept in last night, it does not qualify you to be in this room. Nobody moves. Nobody speaks. 32 law students watch a 16-year-old girl bend down and pick up her scattered pages off the floor. One by one. Slowly, in complete silence. The narrator's voice comes in low. In 4 hours, a $340 million contract will come down to a single hidden clause. 12 attorneys won't find it. She will. And every person in this room will remember exactly what they did in this moment. Don't go anywhere. This story will stay with you. Drop your location and local time in the comments. And if you haven't subscribed yet, you might want to, because what happens next changes everything. The brief landed on the floor at 9:14 a.m. By 9:16, Zara Mitchell had picked up every page, straightened them, folded them back into her notebook, and walked out of Hale's lecture hall without a word. She didn't run. That was the thing people who watched the video later couldn't understand. They expected her to cry, to argue, to say something. She didn't. She walked the same way she always walked, carefully, deliberately, like someone who had learned a long time ago that the world punishes you twice if you show it how much it hurt you the first time. The hallway outside smelled like coffee and new carpet. Students brushed past her without looking. A girl in expensive boots laughed at something on her phone. A boy in a Yale Law hoodie held the door open for the person behind him and let it swing shut before Zara reached it. She sat down on the front steps of the building, opened her notebook to page 43, kept working. She was 16 years old. She had been homeless for 8 months, and she had more important things to do than cry on Professor Edmund Hale's steps. Inside the lecture hall, a third-year student named Devin had filmed the whole thing on his phone. Not to report it, not to help. He posted it to the Yale Law student group at 9:19 a.m. with no caption. Just the video, 47 seconds long, starting from the moment Hale snatched the brief and ending with Zara picking up the last page off the floor. By 11 a.m., it had 127 views. The top comment, posted by a user named Zara Would Never Know, read, LOL, she really thought she could walk into Yale Law. 34 people liked it. 2 people replied with laughing emojis. 1 person wrote, the audacity. Nobody reported the post. Nobody tagged administration. Nobody typed a single word in Zara's defense. She was sitting on the library steps 2 blocks away when she heard 2 students walk past, one of them saying, yeah, the video's already got like 100 views. Did you see her face when he dropped it? They didn't notice her sitting there. They never did. She looked back down at her notebook. Page 43. A citation she'd been building for 6 weeks. Mitchell versus State of Illinois. Appellate grounds. Employment contract clause. Section 4B. Subsection 2. Her handwriting was small and precise. The kind of handwriting that comes from always being careful not to waste paper. Her father's name was Marcus Mitchell. He had been a financial compliance officer at a mid-size investment firm in Chicago. 3 years ago, at the age of 42, he had done what he believed was the right thing. He flagged irregularities in the company's internal accounts, significant ones. Millions of dollars, moved in ways that didn't match the documentation. 3 months after he filed his internal report, Marcus Mitchell was arrested. The charges: embezzlement. The same funds he had reported. The same accounts. Suddenly the paper trail pointed at him. His public defender was 27 years old and handling 14 cases simultaneously. The trial lasted 4 days. Marcus was sentenced to 7 years. Zara's mother, Angela, died 11 months later. A stroke, the doctors said. Zara had her own word for it. Foster care lasted 4 months. The family was not cruel, but the system was indifferent in the particular way that systems are indifferent to children. It has already decided are temporary. And Zara had never been good at pretending she didn't notice things. She noticed everything. Always had. She left the foster home on a Tuesday in November with her mother's rosary, her notebook, and a water-damaged copy of Black's Law Dictionary she had borrowed from the Carver Street Public Library and never returned. She figured Mrs. Abernathy would understand. Mrs. Ruth Abernathy had worked the reference desk at the Carver Street branch for 35 years. She was 67 years old, wore the same 3 cardigans on rotation, and had the particular gift of seeing children clearly without making them feel seen, which is the rarest and most valuable gift a librarian can have. She had noticed Zara at 13. Not the first day, not even the first week, but after the 3rd week of watching a quiet girl carry the same graduate-level legal texts to the same corner table and read them with the focused stillness of someone doing something urgent, Mrs. Abernathy began leaving books out, not handing them to her, not making a production of it, just leaving them on the table near where Zara sat. Corbin on contracts, Wigmore on evidence, Garner's Dictionary of Legal Usage, graduate texts, bar exam prep books, case law anthologies. Zara read them all. She read a page once and it stayed, every word, every footnote, every citation. She didn't know there was a clinical name for it. She just knew that reading was the one thing the world hadn't taken from her yet. One night in February, the library was closing at 9, and the temperature outside was 11 degrees. Zara was still at her table. Mrs. Abernathy made her rounds, turned off the lights section by section, checked the back reading room last. She found a folded blanket on the table, a brown paper bag with a sandwich and an apple, and the back door left unlocked. She and Zara never spoke about it. Not once. The library had closed for renovations 8 months ago. That was when everything got harder. Shelters when available. Subway platforms when not. Museum steps. And sometimes, when she needed to feel close to something that still made sense, the steps of the federal courthouse on South Dearborn Street, where her father's case had been filed, and argued, and lost. She was still carrying page 187 of his trial transcript, folded into the front cover of her notebook. She had read it so many times she could recite it from memory. The clause in her father's employment contract, Section 4B, subsection 2, that should have shielded him from prosecution. 29 words that his public defender had never mentioned. Not once. Not in 4 days of trial. She just needed someone to listen. 2 blocks away, on the 14th floor of a glass building on West Madison Street, a $340 million deal was beginning to fall apart. And nobody in that building had any idea that the answer to their problem was sitting on a library step, working in a notebook, in handwriting too small to waste paper. Not yet. The 14th floor of Whitfield Law Group did not look like a place that panicked. It looked like a place that charged $850 an hour and expected the world to behave accordingly. Dark wood paneling, framed case victories on the walls, a reception desk staffed by a woman named Claire, who had, in 11 years, never once visibly flustered. At 10:47 a.m., Claire was visibly flustered. The fax machine in the corner had printed 12 pages at 10:31. Those pages had gone to James Whitfield at 10:33. By 10:40, every associate on the floor had been pulled into the main conference room, and the particular silence that followed, the kind that seeps under doors and into hallways, told everyone from the paralegals to the mailroom that something had gone seriously wrong. James Whitfield stood at the head of the conference table. He was 45 years old, the son of a man who had built this firm from a 2-room office in Bronzeville, and he had inherited both the firm and his father's particular quality of stillness under pressure. He read the fax a second time. Then he set it down. "Cole filed an emergency objection at 10 this morning," he said. "He's claiming a hidden indemnity clause in Appendix D renders the entire Nexus-Hartwell agreement void under Illinois commercial law. Signing is in 6 hours. If we don't resolve this before 4 o'clock, the deal collapses." The Nexus Capital and Hartwell Industries merger had taken 19 months to negotiate. $340 million. 47 artifacts of corporate restructuring. Employment guarantees for 2,300 workers. A tax structure that had required sign-off from counsel in 4 states. It was the largest deal Whitfield Law had ever shepherded. Dr. Leonard Voss sat at the far end of the table. He was 62, silver-haired, and had been retained as lead contract litigator, specifically because his reputation was supposed to prevent exactly this kind of last-minute ambush. He reviewed the objection with the expression of a man encountering an insult. "Cole is bluffing," he said. "The clause doesn't exist. I reviewed Appendix D myself." Sophie Reyes, 28, third chair on the case, had been awake since 3 in the morning. She had already run 2 searches. She set her legal pad on the table carefully. "I'm not sure he's bluffing, Dr. Voss. The language in subsection 7C is unusual. The syntax doesn't match standard Illinois commercial drafting." Voss looked at her the way senior partners sometimes look at junior associates, like he was deciding whether her comment was worth the oxygen it had cost him. "Sophie, I've been doing this for 30 years. "Yes, sir." She didn't say anything else, but she didn't cross out what she'd written either. The problem, the real problem, the one nobody wanted to say out loud, was that the disputed language in Appendix D was not standard anything. It was archaic. Commercial Latin embedded in a subordinate clause of a technical addendum, written in a drafting dialect that had last appeared with any regularity in corporate contracts somewhere around 1944. None of the 4 associates had encountered it before. Voss had not encountered it before, though he would not say so. The contract was 847 pages long, and the relevant section occupied 11 lines on page 31 of a 47-page appendix that most people had treated as boilerplate. They had 6 hours, and nobody in the room could read what it said well enough to fight it. Downstairs, at that precise moment, the glass lobby doors opened, and Zara Mitchell walked in. Claire recognized her immediately. 2 months ago, this same girl had walked through those same doors and asked to speak with someone about a wrongful conviction case. Claire had given her a form. Zara had filled it out. Claire had processed it with the standard junior associate review queue, which meant Sophie Reyes had looked at it for approximately 40 seconds before marking it insufficient grounds, no retainer capacity, and moving on. Zara had waited 40 minutes in the lobby before Claire told her the firm couldn't help her. During those 40 minutes, there had been a printed copy of the Nexus-Hartwell contract sitting on the side table in the waiting area. A full draft, 847 pages, left there by an associate who had stepped away from the copy machine. Zara had picked it up, read it the way she read everything. Completely. Once. The pages turning with the quiet efficiency of someone for whom reading was not recreation, but survival. And put it back before Claire noticed. That was 2 months ago. She had not forgotten a single page. Now she stood at the reception desk and said simply, "I need to speak with Mr. Whitfield. It's about the Nexus Hartwell contract. I know where the hidden clause is." Claire's expression did not change. "Miss, I told you before, the firm isn't—" "The clause is on page 31 of Appendix D, paragraph 9, subsection C2. It's written in a commercial Latin dialect from the 1940s. It looks like a standard indemnity clause, but it isn't. If Mr. Whitfield presents it as enforceable in Illinois arbitration, he'll lose." Claire opened her mouth, closed it. The elevator at the end of the hall opened. James Whitfield stepped out, jacket off, reading a document, the focused expression of a man with 5 problems and 4 hours. He registered Claire's expression first, the particular look of someone who needed him to deal with something, and then he registered Zara. 16 years old, oversized hoodie, mismatched sneakers, a notebook held against her chest like a shield. He stopped. He looked at her for a moment that lasted slightly longer than it should have. "What did you just say?" he asked. He gave her 5 minutes. That was what he said. He led her to the secondary conference room, not the main one where Voss and the associates were working, but the smaller one off the hall, the one used for client intake meetings, with a round table and 4 chairs and a window that looked out at the side of another building. He set a printed copy of Appendix D on the table in front of her. 47 pages, single-spaced, the kind of dense legal typography that made most people's eyes blur after the first paragraph. "You have 5 minutes, he said. "Tell me what you see." Zara sat down, opened to page 1, and began to read. She did not skim, she did not scan. She read the way she always read, completely, with the particular quality of attention that looked from the outside almost like stillness. Her eyes moved steadily down each page. She turned them at intervals that made Sophie, standing in the doorway with her legal pad, unconsciously count the seconds. 6 pages per minute. Then 7. The associates who had drifted to the doorway exchanged glances. One of them, a second year named Brian, leaned toward Sophie and murmured something. Sophie shook her head once, sharply, and he went quiet. Dr. Leonard Voss appeared at the doorway at minute 4. He took in the scene, the girl, the document, Whitfield standing against the wall with his arms folded, and his expression did the thing it always did when something offended his professional dignity. It went very still, very controlled, and very cold. "James." His voice was low. "A word." "In a minute." "Now, James." He stepped into the hall. Whitfield followed. Voss kept his voice down, but not down enough. "This is a $340 million case. You have a 16-year-old girl off the street reading privileged documents in our conference room. If Cole finds out—" "She walked in with the analysis, Leonard. She walked in with a guess. There's a difference. Then let her guess." Whitfield went back inside. At the table, Zara had not looked up. She turned the last page of Appendix D, read the final paragraph, and set the document down. She picked up the highlighter that Sophie had quietly slid across the table 2 minutes earlier, without being asked, without a word, and opened back to page 31. She circled paragraph 9, subsection C2. "There," she said. "That's not standard indemnity language. It's a modified Llewellyn clause, a commercial law construct from 1947, used primarily in interstate trade contracts in the post-war period. It's only been held enforceable in 3 states, Ohio, Pennsylvania, and Michigan. Illinois courts have rejected it twice, most recently in 2009. The room was quiet. Nobody knew what a Llewellyn clause was. That was the problem. That was the specific, embarrassing, professionally significant problem standing in the middle of the room. Voss broke the silence first. That is not a recognized legal term. His voice was flat, certain, the voice of a man who had never once been wrong in a conference room and did not intend to start today. Zara looked at him. Shall I cite the case law? Something shifted in the room. It was small, the kind of shift you feel rather than see, like a change in air pressure before weather. Brian stopped writing on his legal pad. Sophie looked at the floor. Whitfield looked at Voss. Voss turned without a word and walked to the adjoining office. He opened his laptop. He began to type. What happened next took 4 minutes and 11 seconds, which Sophie would later recall with uncomfortable precision because she watched the clock on the wall the entire time, waiting. Voss searched. His face gave nothing away at first. The professional mask of a man who expected to find nothing and was going to find nothing and was going to be right. Then his typing slowed. Then it stopped. He leaned forward. He read something on his screen. He read it again. He did not come back into the conference room. He stepped into the hallway instead, and he made a phone call. Sophie was the one who took the call back 14 minutes later. The receptionist forwarded it to her desk extension. A return call from the Department of Child and Family Services, responding to a report filed by a Dr. Leonard Voss regarding an unaccompanied minor being utilized in a legal capacity without guardian consent. Sophie held the phone for a moment. She looked through the glass partition at the conference room, at Zara, bent over a second document now, highlighter moving, completely absorbed. At Whitfield, standing beside her, reading over her shoulder, his expression no longer the polite skepticism of a man giving someone 5 minutes. At Brian, who had sat down across from Zara and was quietly pulling up references on his tablet without being asked, Sophie looked at the callback message on her notepad. Dr. Leonard Voss, DCFS, unaccompanied minor. She understood exactly what it was. It was not concern. It was not care. It was a mechanism, clean, bureaucratic, dressed in the language of child welfare, designed to remove a 16-year-old girl from a room before she could prove something that would embarrass the wrong people. Sophie tore the notepad page off carefully, folded it once, and placed it in the top drawer of her desk. She closed the drawer. Then she picked up her legal pad and walked back to the conference room, where Zara had just found the second error, buried in a subordinate clause on page 38, that everyone, including Voss, had read as standard boilerplate for 19 months. There's another one, Zara said quietly. She didn't look up. And there's a third. Give me 2 more minutes. Nobody in the room said a word. 3 hours until arbitration. And Raymond Cole had just filed his second motion. While Voss was still in the hallway, while Cole's second motion was being printed and distributed, while the associates were pulling up Illinois Commercial Code on 3 separate laptops, the narrator steps back. Because you cannot understand what Zara Mitchell did in that conference room without understanding what it cost her to get there. Marcus Mitchell had been a careful man. That was the thing his colleagues remembered most about him, the thing that came up again and again in the character statements that nobody entered into evidence at trial. Careful. Methodical. The kind of man who kept receipts for everything, who read contracts before signing them, who believed, with the particular faith of someone who had grown up with very little, that the rules existed to protect people if you followed them precisely enough. He had been a financial compliance officer at Greystone Capital Management for 6 years. He liked the work. He was good at it. And in the spring of 3 years ago, going through routine internal documentation, he found something that didn't belong. The irregularities were not subtle once you knew where to look. Funds moved between subsidiary accounts in patterns that mimicked legitimate transfers, but didn't match the corresponding documentation. Small amounts at first, then larger ones. Over 18 months, Marcus calculated, approximately $4.2 million had been quietly redirected in ways that the official records did not reflect. He filed an internal report on a Thursday. He was methodical about it, documented everything, kept copies, followed every protocol the compliance manual specified. On the following Monday, his access credentials were suspended. 3 months later, he was arrested. The charges listed his name next to the same accounts, the same amounts, the same time frame. Someone had rebuilt the paper trail with him at the center of it. His public defender, a 27-year-old named Travis Odom, who was simultaneously handling 14 other cases, had 4 days to prepare and approximately 9 hours of actual preparation time. The trial lasted 4 days. Marcus Mitchell was sentenced to 7 years. Zara was 13 years old. She sat in the third row of the courtroom and watched her father turn to look at her before they took him away. He didn't say anything. He just looked at her the way people look when they are trying to memorize something they're afraid they won't see again for a long time. She read the trial transcript for the first time 3 weeks later, in the back corner of the Carver Street Library. All 312 pages. Once. She found the error on page 187. It was not dramatic. It was 29 words in a subordinate clause of her father's employment contract. Section 4, B, subsection 2, a whistleblower protection provision that explicitly shielded compliance officers from prosecution related to the accounts they were assigned to monitor. Travis Odom had never mentioned it. Not in opening arguments, not in cross-examination, not in closing, not once in 4 days. 29 words that should have ended the prosecution's case before it began. Zara copied the clause into her notebook, in her small, precise handwriting. Then she built everything else around it. Over the next 3 years, working at the Carver Street Library table with graduate texts that Mrs. Abernathy left out without comment, she taught herself contract law, employment law, appellate procedure, post-conviction review standards. She read Corbin on contracts cover to cover. She read every wrongful conviction appeal filed in Illinois in the past decade that she could access through public court records. She filled 43 pages of her notebook. Mrs. Abernathy watched all of it without ever making Zara feel watched. Once, on a Tuesday afternoon, she set a cup of tea on the table next to Zara's legal pad without saying a word and walked away. Zara drank it without looking up. That was the entirety of their acknowledged relationship for 2 years. One night in February, the temperature dropped to 11 degrees. The library closed at 9. Zara was still at her table at 8:55, moving slowly, packing her notebook with the deliberate care of someone who had no good reason to hurry toward wherever they were going next. Mrs. Abernathy made her closing rounds. She turned off the lights in the main stacks. She checked the periodicals room. She checked the children's section. She checked the back reading room last. On the table, a folded wool blanket, a brown paper bag containing a turkey sandwich, an apple, and a small bag of crackers. And the back door, which had a push-bar exit that did not require a key from the inside, left carefully unlocked. Mrs. Abernathy's footsteps receded toward the front entrance. The main lights went off. The emergency exit signs cast everything in dim red. Zara sat down, opened her notebook to page 43, and kept working. She never told Mrs. Abernathy what those nights meant. She didn't have the language for it. What she had instead was the particular loyalty of someone who has learned that most kindness announces itself, and that the kindness which doesn't announce itself is the kind that actually keeps you alive. The library closed for renovations 8 months ago. Everything got harder after that. Shelters when available, which was not always. Subway platforms, museum steps, and sometimes, on the nights when she couldn't sleep, and the city felt very large, and her father felt very far away, the steps of the federal courthouse on South Dearborn, where his case had been filed, and argued, and decided, and where she had always felt, irrationally and completely, that sitting there meant she hadn't given up. She still had the transcript in her notebook. Page 187 folded separately, at the front, worn soft at the creases from 3 years of handling. 29 words. She had walked into 17 law offices in the past 3 years. She had been turned away from 16 of them. The 17th had given her a form and a 40-minute wait, and a rejection notice processed by a junior associate who had spent 40 seconds on it. During those 40 minutes, she had read 847 pages. And now, in a conference room on the 14th floor, Voss's laptop was open in the next room, and his face had changed, and the back reading room door was very far away, and Zara Mitchell had just found the 3rd error. She looked up for the first time in 20 minutes. "You should probably call your client," she said to Whitfield. "Before Cole does." Voss came back into the conference room at 11:43 a.m. He did not sit down. He stood in the doorway with his laptop under his arm and looked at Zara the way you look at something that has appeared in a place where it has no business appearing, not with anger exactly, but with the specific displeasure of a man whose understanding of the world has been quietly rearranged without his permission. He said nothing about what he had found on his screen. He would never say anything about it directly. That was not how men like Leonard Voss operated. Instead, he set his laptop on the side table, pulled out the chair at the far end of the conference table, and sat down with the careful deliberateness of someone reasserting territorial ownership of a room. "James," he said, "a word about process." Whitfield looked up from the document Zara had annotated. "Go ahead. We have 2 hours and 40 minutes until we walk into arbitration. If we present an argument built on an interpretation that opposing counsel can challenge on credentialing grounds." "Her interpretation is correct," Sophie said. It came out quieter than she intended, but it came out. Voss looked at her. "Sophie." "All 3 errors. I cross-referenced them. She's right on all 3. The room was quiet for a moment. Voss adjusted his cufflinks. "That's not the point." "What is the point?" Whitfield asked. "The point is that Raymond Cole will ask, in that arbitration chamber, who produced this analysis. And when the answer is a 16-year-old girl with no credentials, no bar admission, no academic record for the past 8 months, and no permanent address, he will use that to bury everything we present. Doesn't matter if she's right. Perception is the argument." Nobody spoke, because the frustrating, infuriating, professionally ugly truth was that Voss was not entirely wrong. That was what made it so hard to sit with. Whitfield turned to Zara. "You heard him. You can walk. I won't stop you. I won't hold it against you." Zara had been listening with the stillness she always had. The quality of attention that looked like calm, but was actually something closer to conservation, like an animal that has learned not to spend energy it doesn't have. She looked at Whitfield. Then she looked at the transcript page folded into the front of her notebook. "My father has 4 more years in a cell for something he didn't do," she said. "I've been trying to find someone to listen for 3 years. I'm not walking." The room held that for a moment. Then Whitfield's phone rang. He looked at the screen. Dean Patricia Holloway, Yale Law School. He knew the name. Holloway sat on Nexus Corporation's advisory board. He set the phone on the table and pressed speaker. James. Her voice was warm the way marble is smooth. Surface temperature. No depth. I'm calling as a friend. I've heard there's a situation developing at your firm involving a young woman. A vagrant, I'm told. I want to strongly encourage you, before this becomes something that reflects badly on everyone involved, to resolve it quietly and professionally. Resolve it how, Patricia? Remove her from the case. Whatever she's told you, whatever you think she's found, find another way. The optics of this, James. A homeless black girl advising on a $340 million corporate matter. The delegation alone. Whitfield picked up the phone, took it off speaker, and held it out toward Zara. She looked at the phone, looked at him. He nodded once. She took it, listened for 4 seconds, then handed it back. Whitfield put it to his ear. Patricia, she heard you. He ended the call. The silence that followed had a different quality than the ones before it. Heavier, more honest. Then the fax machine in the hall chirped. Sophie went to check it. She came back 30 seconds later, and her expression was the careful neutral of someone working very hard not to show what they were feeling. She set the fax on the table in front of Whitfield without a word. He read it, folded it, put it in the inside pocket of his jacket. What is it? Brian asked. Whitfield straightened his jacket. Raymond Cole filed a complaint with the Illinois State Bar Association 17 minutes ago. He's alleging that I'm utilizing an unlicensed minor to perform legal analysis in an active arbitration matter. If the complaint is accepted within the next 24 hours, my license goes to review. The room went very still. Cole had timed it perfectly. Too late to respond, too early to ignore. 17 minutes before they needed to walk out the door. Enough time to detonate something, not enough time to defuse it. Brian pushed back from the table. James, we're going. Whitfield's voice was even, completely even. He looked at Zara. Are you ready? She was already closing her notebook. She tucked it under her arm. Mismatched sneakers on the marble floor. Borrowed blazer from the coat closet. Sophie had found it without being asked. A women's medium that was too large in the shoulders and too long in the sleeves, but it was something. Zara rolled the cuffs up twice without looking at them. Are you? She asked. He almost smiled. Let's go. They walked to the elevator. 6 people. One of them 16 years old, homeless, carrying a notebook with 43 pages of work that nobody had ever asked to see. The elevator doors closed. 3 hours of work. 1 hidden clause. 1 father in a cell in Stateville. And Raymond Cole was already in the arbitration chamber, arranging his papers, completely certain he had won. Raymond Cole had excellent posture. That was the first thing you noticed about him in a room. The particular straightness of a man who had spent 30 years winning arguments and had let his spine remember every one of them. He was 55, silver-templed, with the kind of face that looked authoritative in photographs and condescending in person. His legal team occupied 1 full side of the arbitration table. 6 attorneys, 2 paralegals, 3 open laptops, color-coded binders arranged with the precision of a courtroom that had been prepared for days. Whitfield's team took the opposite side. 4 people, 2 laptops, 1 accordion folder, and Zara, at the end of the table, her notebook open, her borrowed blazer sleeves rolled twice, her mismatched sneakers not quite reaching the floor from the adult height chair. Cole saw her the moment they walked in. His eyes moved across her the way eyes move across something irrelevant, and then moved back, because something had registered that his brain needed a second pass to process. A teenager. At the table. He looked at Whitfield with an expression that began as amusement and sharpened into something closer to contempt. "James," he said pleasantly. "Really?" Whitfield set his folder on the table. "Raymond." Judge Carol Trent entered at precisely 1 p.m., 62 years old, 20 years on the federal bench, with the economy of movement of someone who had stopped performing authority because she simply had it. She took her seat, reviewed the room briefly, and her eyes settled on Zara for exactly 2 seconds before moving on. "We're here on an emergency objection filed this morning by counsel for the opposing party," Judge Trent said. "Mr. Cole, you have the floor." So Cole stood. He was, Zara noted, a very good speaker. His argument was polished, architecturally sound, delivered with the confident rhythm of someone who had rehearsed it enough times to make it sound unrehearsed. The forgery allegation came 40 minutes in, a pivot from the indemnity clause argument, smooth as a gear change. He presented 3 exhibits: a handwriting analysis, a forensic document report, a corporate signatory list showing that the name on the original merger memorandum did not match the authorized signatories on file. "The signature is fraudulent," Cole said simply, "which renders the foundational document of this entire agreement invalid, not voidable. Void. The contract does not exist." He sat down with the composure of a man who had just placed a winning hand on the table. Judge Trent looked at Whitfield. "Counsel?" Whitfield stood. "Your Honor, we'd like to submit a response to the forgery allegation." He paused. "Our research consultant will present." Cole's head turned, slowly. "I'm sorry. Your what?" "Research consultant, Zara Mitchell." The word consultant landed in the room with a sound that wasn't quite a sound, more like the feeling of every person in the chamber recalibrating something simultaneously. Cole's senior associate leaned toward him and whispered something. Cole shook his head once, still watching Zara stand up. She opened her notebook to the page she needed. She did not look at Cole. She looked at Judge Trent. "The signature is real," she said. Her voice was steady, the voice of someone who had rehearsed nothing because she had simply learned everything. "It's not a forgery, but it has been misattributed. The signatory line on the merger memorandum references the Chief Operating Officer's execution authority. Mr. Cole's forensic analysis compared it to the CEO's signature on file. A different officer, a different signature block entirely. The comparison was never valid." Cole's composure held, but something behind his eyes shifted. "Your Honor, this is—" "Let her finish," Judge Trent said. Not unkindly, but with complete authority. Zara continued. "The corporate registration filings from 2019, public record, Illinois Secretary of State, filed March 14th, list the COO's execution authority explicitly for merger instruments. The signature matches. I can provide the filing number." Sophie had the filing on her laptop already. She turned the screen toward the judge's clerk. Cole was very still now. The comfortable posture was still there, the spine still straight, the hands still folded. But the stillness had changed quality. It was no longer the stillness of confidence. It was the stillness of a man doing rapid, private calculations. "Mr. Cole," Judge Trent said, "was your forensic analysis conducted against the COO's signature or the CEO's?" A pause. 1 second. 2. "We'll need to verify. Was it conducted against the COO's signature?" "Your Honor, the exhibits we've submitted—" "Answer the question, Mr. Cole." The room didn't breathe. "No," he said, "it was not." Something moved through the room then. Not noise, but its opposite. The specific quality of silence that follows when something everyone suspected is confirmed out loud. Judge Trent made a note. She did not look up while she wrote. "We'll take a 15-minute recess." Cole stood as the judge left. He looked at Whitfield, and for one unguarded moment, the mask came entirely off. Not anger, something closer to recognition. The expression of a man who has just understood, fully and completely, that he is not in the room he thought he was in. Then he looked at Zara. She was already sitting back down, opening her notebook to the next page. She had not watched his expression change. She didn't need to. Whitfield leaned toward her during the recess, voice low. "You said you came here 2 months ago about your father's case." "Yes. Tell me about page 187. She had been waiting 3 years for someone to say those words. She reached into the front cover of her notebook, unfolded the transcript page, worn at the creases, soft from handling, the margins filled with her small, precise handwriting. She placed it on the table between them. He read it. His jaw tightened slowly. The way a door closes against a frame, it fits too well. "His public defender never raised this," he said. It was not a question. "No. This is grounds for appeal." She didn't answer. She had known for 3 years. She just needed someone else to see it. Whitfield folded the page carefully, looked at her. Then he picked up his phone and made 2 calls. The second one was to a post-conviction review attorney named Diane Okafor, who owed him a favor and answered on the second ring. The recess ended. They went back in. And Raymond Cole had 15 minutes left to salvage something from the wreckage of the case he had been certain 2 hours ago that he had already won. The recess lasted exactly 15 minutes. When Judge Carol Trent returned, the room had rearranged itself in ways that had nothing to do with chairs. Cole's team was still on their side of the table, still color-coded and organized, but the binders had not been opened during the break. 2 of his associates were looking at their laptops with the focused urgency of people searching for something they were not finding. Cole himself sat with his hands folded and his posture intact, which meant nothing except that he had very good posture. Whitfield's side was quieter. Sophie had her legal pad open. Brian had his laptop angled toward Zara. Zara had her notebook open to a fresh page, her pen uncapped, and the particular stillness that the room had begun to recognize as the opposite of emptiness. Judge Trent settled her reading glasses and looked at Cole. "Mr. Cole, given the corporate registration documentation submitted during the recess, I'd like you to address the evidentiary basis for your forgery claim." Cole stood. "Your Honor, we maintain that the signatory discrepancy raises sufficient questions to warrant—" "The discrepancy," Judge Trent said, "appears to be in your analysis, not in the document. You compared the signature to the wrong officer. Is that correct?" Another pause. Shorter this time. He had run the calculations already. "In light of the filing submitted by opposing counsel, we are prepared to withdraw the forgery allegation pending further review." The room did not react visibly. Rooms like this one were too expensive for visible reactions. "Withdrawn," Judge Trent said, and made a note. "We return then to the original objection. The indemnity clause in Appendix D, Mr. Cole, your position." Cole presented his indemnity argument. It was still good. Stripped of the forgery claim, it was leaner, more focused, and in the hands of a lesser opponent, it would have been enough. He argued enforceability, cited 3 Illinois cases, submitted 2 supporting briefs. He was precise and he was confident, and he sat down having done everything correctly. Judge Trent looked at Whitfield. Whitfield stood. "Your Honor, The clause in question is not a standard indemnity provision. Our analysis identifies it as a modified Llewellyn Clause, a commercial law construct originating in post-war interstate trade contracts. We'd like our research consultant to address the court directly. Cole was on his feet before Whitfield finished the sentence. Your Honor, I must object to the use of an unlicensed, uncredentialed minor as a presenting consultant in a federal arbitration proceeding. It's irregular, it's unprecedented, and frankly, Mr. Cole. Judge Trent's voice did not rise. It didn't need to. I'll determine what's appropriate in my chamber. Sit down. He sat. Judge Trent looked at Zara. Really looked. The assessing, unhurried attention of someone who had spent 20 years reading people across a table. Young lady, counsel has asked you to address the court. Before you do, I have a question. Yes, ma'am. How old are you? 16, Your Honor. The room absorbed this. Cole's senior associate wrote something on a notepad and underlined it twice. One of the video screen participants leaned slightly forward. And where did you receive your legal training? Zara did not hesitate. The Carver Street Public Library, ma'am. Nobody laughed. The room was too expensive and too tired and too close to something it didn't fully understand yet to laugh. Judge Trent studied her for a moment longer. Then she nodded. Proceed. Zara stood. She opened her notebook but didn't look at it. She had looked at it already. Had looked at it 3 years ago and every day since, and the pages were as permanent in her memory as anything she had ever known. The clause in Appendix D, paragraph 9, subsection C2, uses a conditional indemnity structure that does not conform to Illinois Commercial Code. The specific construction, a liability cap tied to a performance threshold defined by a third-party valuation, derives from a drafting model introduced in Llewellyn versus Commercial Trust in 1947. She paused. That case established the clause as valid in Ohio. It was adopted in Pennsylvania in 1951 and Michigan in 1963. Illinois courts considered it twice. Harmon Industrial Corp. versus State of Ohio in 1953, and again in Meridian Holdings versus Blackwell Partners in 2009. It was rejected both times. The Illinois Commercial Code, Section 2-719, explicitly limits consequential damage caps in commercial contracts to terms negotiated at the time of execution, not defined by post-execution third-party assessment. This clause fails that standard. She sat down. The room was silent, not the polite silence of consideration. The specific, weighted silence of a room in which something has just been said that cannot be unsaid. Cole's senior associate had stopped writing. Cole himself was looking at a point approximately 6 inches above the surface of the table, the expression of a man running the same calculation a third time, hoping the answer will change. Judge Trent removed her glasses, cleaned them with the cloth from her breast pocket, put them back on. She looked at the clause on the projected document. She looked at her own notes. She looked at Zara. Mr. Cole, she said. Response? Cole stood. He was still composed. The posture was still excellent. But something had gone out of the room that had been his when he walked in. The particular gravitational weight of absolute certainty, and its absence made the excellent posture look like what it was: performance. Your Honor, he said, we would request a brief recess to consult. You've had your recess, Mr. Cole. A pause that lasted exactly as long as it needed to. We have no further response to the Llewellyn analysis, he said. Judge Trent wrote something, set her pen down, folded her hands. The indemnity clause in Appendix D is unenforceable under Illinois Commercial Code Section 2-719. The objection is dismissed. The Nexus Hartwell agreement is valid as executed. Signing will proceed. She looked at Zara one final time. Not the assessing look from before, but something different. Something that a 20-year federal judge allowed herself approximately twice a decade. Then she gathered her materials and left the room. Cole remained seated for 4 seconds after everyone else had stood. Then he rose, straightened his jacket, and walked to Whitfield's side of the table. His face had completed its journey from contempt to something it had clearly not visited in a very long time. "Who is she?" he said quietly. "Really?" Whitfield looked at him. Exactly who she said she is. The press was not supposed to be there. Emergency arbitration proceedings at the federal building were not public events. They did not generate advance notice. They did not, under normal circumstances, attract journalists from 3 separate outlets to the 4th-floor corridor with press credentials and recording equipment. But Raymond Cole's Bar Association complaint had gone through the clerk's office at 12:43 p.m., and clerks talk, and legal reporters monitor clerk activity the way meteorologists monitor pressure systems. Because the interesting weather is always in the numbers before the storm arrives. By the time Whitfield's team walked out of the arbitration chamber at 3:22 p.m., there were 4 reporters in the hallway, 2 cameras, and a producer from a legal affairs podcast who had driven 40 minutes on a tip. Cole walked out first. He walked past them without stopping, his team forming a quiet buffer around him, all of them moving with the purposeful blankness of people who have decided that speed is the only remaining form of dignity. Nobody called after him. The reporters were looking past him already. Whitfield came out next, and then Sophie, and then Brian, and then Zara, still in the borrowed blazer with the sleeves rolled twice, notebook under her arm, mismatched sneakers on the federal building's marble floor. The cameras found her immediately. That particular quality of attention, the kind that recognizes a story before it can name one, settled on her and didn't move. A reporter from the Chicago Tribune stepped forward. "Mr. Whitfield, can you speak to what just happened in there?" Whitfield stopped. He looked at Zara. She gave him nothing. No direction. No permission. No refusal. She was looking at the middle distance the way she always looked when she was deciding something. He turned to the reporter. "I can speak to what happens when we almost miss something important because it doesn't arrive in the package we expect," he said. "The objection filed this morning against a $340 million corporate agreement was resolved today by a 16-year-old girl named Zara Mitchell. She identified 3 errors that a full legal team missed. She presented the analysis to a federal arbitrator. She was correct on every point." The hallway went very quiet. "She's been homeless for 8 months, Whitfield continued. "She has no formal legal training. She taught herself contract law, employment law, and appellate procedure in a public library on Carver Street. She came to my office 2 months ago about her father's wrongful conviction, and we turned her away." His voice stayed even. "I won't be making that mistake again." A second reporter. "Zara, can we ask you a few questions?" She stood still for a moment. Then she looked at Whitfield, and he nodded once, and she stepped forward to the cluster of microphones. She was 16 years old, in a blazer that didn't fit her, with shoes that didn't match, standing in a federal building hallway under fluorescent lights, while 4 cameras recorded her face. And she was the least uncertain person in the corridor. "I didn't do this to save a deal," she said. Her voice was clear and unhurried. "I did it because 3 years ago someone buried a clause in a contract and destroyed my family, and I needed to understand how that was possible. So I learned." She paused. "The library on Carver Street is the reason I'm standing here. Mrs. Abernathy is the reason I'm standing here. And Mr. Whitfield is the reason I'm standing here. Because he was the first person in 3 years who let me finish a sentence. Nobody said anything for a moment. Then a third reporter. What happens next for you? Zara looked at the question like it was in a language she was still learning. I don't know, she said honestly. I've never been able to think about next. I've been thinking about today for 3 years. That answer, its plainness, its complete absence of performance, was the one that made it onto every broadcast that evening. At 6:14 p.m., Professor Edmund Hale was eating dinner in his faculty apartment 2 miles from the Yale Law campus when his phone began to ring. He silenced it. It rang again. He looked at the screen, a colleague, and answered with mild irritation. And the colleague said, Edmund, turn on the news. He found the coverage in 40 seconds. The federal building hallway. The reporters. The borrowed blazer and mismatched sneakers. The face he had looked at that morning over a brief he had dropped on a lecture hall floor. He sat very still for a long time. At 7:30 p.m., Dean Patricia Holloway called Whitfield's cell. Her voice had completed its journey from warm marble to something flatter and more honest. James, I'd like to speak with the young woman. I'll let her know, he said. She'll decide if she wants to speak with you. He ended the call and relayed the message to Zara, who was sitting in the firm's library with a glass of water and her notebook open, writing something in her small handwriting that she did not explain. She considered Holloway's request for approximately 4 seconds. Maybe, she said. Not today. Not at 8:15 p.m. Sophie found her there. She stood in the doorway for a moment before coming in. The particular hesitation of someone who has something to say and is deciding whether they deserve to say it. She sat down across from Zara. Not beside her. Across. Direct, honest, not softening the geometry. I processed your rejection 2 months ago, she said. I looked at your intake form for 40 seconds. I didn't read past the first paragraph. She didn't look away. I'm sorry. Zara looked at her. I know. I should have. You can look at it now, Zara said. The intake form, the case, you can look at it now. Sophie nodded. She opened her laptop. Then Whitfield knocked on the library door, and both of them looked up, and his expression was the one that people wear when they are carrying news that is going to change something permanently. The post-conviction attorney called back, he said. The post-conviction review was filed 48 hours after the arbitration ended. Diane Okafor worked fast. That was what Whitfield had said about her, and it turned out to be accurate in the specific way that meaningful things are accurate. Not as a compliment, but as a fact of character. She read the trial transcript in one evening. She found page 187. She read the whistleblower protection clause in Section 4(b), subsection 2. Those 29 words that a 27-year-old public defender had never once raised in 4 days of trial. And she called Whitfield at 11:40 p.m. and said simply, "This should never have gone to conviction." The review petition cited 3 grounds: ineffective assistance of counsel, material omission of exculpatory contractual evidence, and newly identified prosecutorial pattern, because Diane had pulled 3 other cases from the same prosecutor's office and found the same mechanism: compliance officers charged with the irregularities they had reported. Marcus Mitchell was not the first. He was the 4th. 6 weeks after the filing, a Cook County judge granted the review hearing. Zara was sitting in her first real apartment in Queens, a studio, small, with one window that faced a brick wall, when Whitfield called with the date. She wrote it in her notebook. Then she sat on the edge of the bed for a long time, not moving, just letting the information exist in the room with her. The hearing lasted 2 days. On the second afternoon, the judge vacated the conviction. Marcus Mitchell walked out of Stateville Correctional Center on a Tuesday morning in March at 9:47 a.m. The air was cold and flat and smelled like exhaust and dead grass, the specific smell of early spring in Illinois that is not yet anything but the absence of winter. He was wearing the clothes he had been wearing 3 years ago when he went in, which no longer fit him correctly in the shoulders. Zara was standing on the sidewalk. She had taken the bus from the train station, arrived 40 minutes early, and stood in the same spot for 40 minutes because she didn't know what to do with herself anywhere else. She was wearing her museum blazer, not borrowed this time, hers now, purchased with the first paycheck from the Whitfield Law Research Fellowship, and her mismatched sneakers, because she had decided she was keeping them. Marcus came through the gate and stopped when he saw her. He stood very still for a moment, the way he had stood in the courtroom 3 years ago when they took him away, trying to memorize something. Then he walked toward her, and she walked toward him, and they met in the middle of the sidewalk and held each other for a long time without saying anything, because there was nothing that language was built to carry that particular weight. The Whitfield Law Research Fellowship had been announced the week before. Paid position, first of its kind at the firm, specifically created for her. Whitfield had presented it without ceremony, sliding the offer letter across the conference table the same way Sophie had once slid a highlighter, and Zara had read it once and signed it. Columbia Law School's early admission program sent their letter on a Thursday. Full scholarship, housing stipend, start date deferred until she completed her secondary education, which the program's director, a woman named Dr. Alicia Barrow, who had called Whitfield personally to ask about Zara, described as a formality we're prepared to accommodate. Mrs. Ruth Abernathy heard about it on the evening news. She was in her kitchen making tea when the segment came on. The federal building hallway footage, Zara in the borrowed blazer, the clear, unhurried voice. Mrs. Abernathy set down her tea. She watched the entire segment. Then she turned off the television, sat down at her kitchen table, and cried for 11 minutes. Good tears. The kind that come when something you believed in without evidence is finally proven right. She closed the Carver Street Library early the next morning and didn't explain to anyone why. Professor Edmund Hale's lecture hall video had been shared 34,000 times by Friday evening. The Yale Law Administration, which had received 11 formal complaints against Hale over 6 years and quietly archived every one of them, convened an emergency review panel on Saturday. By Monday, Hale was on administrative leave pending investigation. The 11 complaints, filed by students of various backgrounds documenting a consistent pattern of targeted humiliation, were reopened. Dean Patricia Holloway appeared before the law school's Board of Trustees on Wednesday. The board member who forced the meeting was a woman named Eleanor Voss, no relation to Leonard, who had watched the news coverage and called an emergency session soon before Holloway had time to prepare a narrative. Holloway resigned on Thursday. The statement cited personal reasons. Nobody who was in that board meeting believed it. Raymond Cole's Bar Association complaint against Whitfield was dismissed in full on the same day as the arbitration ruling. 3 weeks later, the Bar Association opened its own inquiry into Cole, reviewing the complaint filing as a potential abuse of process. Cole's firm settled quietly with Nexus Capital for costs incurred by the emergency objection. The settlement amount was not disclosed. Cole did not comment publicly. Dr. Leonard Voss submitted his resignation from the Whitfield Law retainer 2 days after the arbitration. He did not give a reason. Whitfield did not ask for one. 3 months after the signing, Zara sat in an auditing seat in a Columbia contracts seminar, not enrolled, not yet, but present, with Dr. Barrow's permission and a visitor's badge clipped to her blazer. The professor was young, black, female, with the particular energy of someone who still found the material genuinely interesting after years of teaching it. She asked a question about modified indemnity clauses. Zara's hand went up. The professor called on her. She answered, fully, precisely, with case citations delivered from memory. "Correct," the professor said. She looked at Zara with the assessing focus that good teachers deploy when they recognize something rare. "More than correct. Can you stay after class?" That evening, Zara walked into the Carver Street Library at 6:15 p.m. The renovation was finished. The carpet was new. The reference desk was in the same place it had always been. Mrs. Abernathy was behind it. She looked up when the door opened. She saw the blazer, the notebook, the mismatched sneakers. She looked at Zara for a long moment. Then she nodded once. Zara nodded back. Everything had been said. The narrator's voice came in quiet and final. The clause that freed her father was 29 words long. She found it at 13. It took 3 years for the world to be ready to listen. It did not take 3 years because the answer was hard to find. It took 3 years because the wrong people kept deciding who was allowed to look. Statistics: 1.3 million homeless youth in America. 68% test above average intelligence. Less than 3% access higher education. Not because they cannot, because we keep making decisions about who belongs in the room before they open their mouths. Zara Mitchell did not become extraordinary the day the world decided to notice her. She was extraordinary on the library steps, in the foster home, on the subway platform, at the table with 43 pages that nobody had asked to see. The world did not give her her gift. It only tried to take it. The difference between those two things is everything. If this story stayed with you, drop a comment. Tell us where you're watching from and what time it is there. And if you've ever been told you didn't belong in a room you knew you deserved to be in, we want to hear it. Subscribe if you haven't. The next story is already waiting.